Hi everyone, it's Catherine Preisner. My presentation today is going to be over malpractice, which is a portion of Chapter 7 of our Beauport textbook. To begin, I want to look at a few of the basics in regards to malpractice of the nurse practitioner. To start off, what is malpractice? By a simple definition, malpractice is the failure of a professional to exercise the degree of skill and learning commonly applied by the average prudent, reputable member of the profession. So to understand this definition, it's also helpful to understand what prudent means. Prudent simply means that you care, while we all understand what the term reputable means. So basically, malpractice is acting improperly or unprofessionally so as to cause some type of harm. Speaking of doing no harm, all medical professionals, including nurse practitioners, carry the duty to do no harm. However, nurse practitioners, just like all other healthcare professionals, make hundreds of decisions each and every day, so mistakes are going to happen. It is documented that malpractice lawsuits against nurse practitioners are rare, although they do happen. So just because something doesn't happen very often doesn't mean one shouldn't understand it and its consequences. The financial and emotional consequences of being sued are so dire that it is worth dealing with this subject in depth. I have always found most legal terms to be rather confusing, and I feel like a lot of meanings overlap one another. So in order to progress in an understanding of malpractice, it's first important to understand some basic terms, like what is a lawsuit anyway? First off, a filed lawsuit has absolutely no meaning other than to say that a person believes himself or herself to have been harmed. In all honesty, the blame may be placed on the wrong person and the belief of harm may be unsubstantiated. Secondly, some lawsuits that are filed and that name nurse practitioners do so simply because the nurse practitioner is a member of a team or of caregivers who are being sued, not necessarily because they think that the nurse practitioner caused the harm. Third, unless an insurance company reports a damage award, which means a successful lawsuit or a settlement for damages, against a nurse practitioner to the National Practitioner Data Bank, which is something we will talk about later, a lawsuit may come to light only through a search of county court or insurance company records. If a suit is filed but the plaintiff, which is a person who brings a case against another in a court of law, is unsuccessful in proving the necessary elements for malpractice, there will be no report filed with the NPDB. As it turns out, nurse practitioners are lowest in the rankings of healthcare professionals when comparing the incidence of successful lawsuits against providers. In a study completed in 2006, the chances of paying a malpractice award were 1 in 62 for physicians, 1 in 563 for PAs, and 1 in 1,016 for nurse practitioners. This calculates the incidence of malpractice lawsuits in which nurse practitioners have been named as the primary defendant pretty low, at only 2%. To further understand the terminology, let's take a look at the life cycle of a lawsuit. How does it all work? Well, first, a lawsuit starts with the filing of pleadings with a state court, usually in the county where the incident occurred. A pleading is simply a formal statement of the cause of an action or defense. Some states direct malpractice actions to an arbitration panel, where the case is presented to the panel and its members make a decision in favor of one party. Depending on which state you practice in, either party may appeal, which will lead to a trial. As we all know, in a trial, a judge or a jury will decide in favor of one party. Again, once this decision is made, either party may then appeal this decision to a higher state court. The process of appeal can continue on, although it is rare that a party will seek an appeal to a federal court, and although possible, it is very unlikely that a malpractice case would go all the way to the Supreme Court. Further, the public does not have access to information on malpractice trials unless there is an appeal. Above all, a nurse practitioner who is sued may be left with many emotional scars regarding the entire event. She may feel like leaving the profession. She may doubt her ability to make sound decisions. She may even revert to over-referring and seeking unnecessary consultations just to make sure she's covering all of her bases. Nurse practitioners who have been sued may find that their malpractice insurance rates have increased and may have to pay some legal fees. It is helpful to note that boards of nursing do not automatically investigate nurse practitioners who have lost in malpractice suits. If the nurse practitioner is reported to the board by someone involved in the case, the board will most likely investigate that individual. The board will also most likely investigate the individual if the negligence approaches the level of gross negligence, which is the intentional failure to perform a professional duty in reckless disregard of the consequences. So basically, saying a nurse practitioner who purposely withholds treatment, knowing the outcome. The table to the bottom right of this slide simply shows the percentage of malpractice claims against nurse practitioners by their specialty. I thought this was an important piece of information for all of us to be wary of, as most of us will be family nurse practitioners once we graduate. Just to note that the highest percentage of claims were against family nurse practitioners at 41.4%. Now that we have at least a small understanding of the basics of lawsuits, let's dig a little deeper into the elements of malpractice. In order to uphold a malpractice case in court, a plaintiff must prove the following elements. First, the nurse practitioner owed the plaintiff a duty. A duty is established when there is a provider-patient relationship. It's important to understand just what constitutes a provider-patient relationship. A visit to the nurse practitioner office by a patient establishes this relationship, but that office visit does not have to happen necessarily to establish duty. Duty can be established by a simple telephone call or casual conversation in the parking lot. To be put simply, if a nurse practitioner gives any kind of professional advice or treatment, regardless of the setting, a duty is established. Next is whether or not the nurse practitioner's conduct fell below the standard of care. Nurse practitioners are duty-bound to use such reasonable, ordinary care, skill, and diligence as nurse practitioners in good standing in the same general type of practice in similar cases. Did the nurse practitioner act as any other diligent nurse practitioner would in the same circumstance? If a nurse practitioner is sued for malpractice, the standard of care will absolutely be argued in court. Third looks at whether or not the nurse practitioner's conduct caused the plaintiff's injury. For malpractice to have occurred, a breach of the standard of care must have caused an injury to the plaintiff. Our book gives a great example that is very helpful in understanding the concept. In a nutshell, the example was a patient with a penicillin allergy was prescribed penicillin for an ear infection. Upon leaving the office, the patient was stung by a bee and fell and hit her head, causing injury and permanent scarring to her face. The patient ended up suing the clinic and the nurse practitioner, saying that the nurse practitioner had a duty to the patient, that the nurse practitioner breached the standard of care by prescribing penicillin to a penicillin allergic patient, and the patient suffered an injury. There is no malpractice in this case. Why? It's pretty simple, because although all of these claims are true, there is no malpractice because the breach of the standard of care, which was prescribing penicillin to an allergic patient, is not what caused the patient's injury. So if you want to remember anything here, it's that in order to uphold in court, the breach of the standard of care must have caused the injury to the patient. Fourth looks at whether or not the plaintiff was injured. A nurse practitioner may be terribly negligent, but if there is no injury, there is no malpractice. Using the same example as earlier, so if a nurse practitioner prescribes penicillin to a patient who is allergic to penicillin, and the patient takes the penicillin but has no reaction that injures him, then there is no malpractice. Before we move on with the rest of our discussion, I want to stop and go over an example of some lawsuits brought against nurse practitioners. Our text really gives some great, easy to follow examples, making the concept super easy to understand. I'm only going to go over one of these examples because they are all listed in our book. They start on page 274 of our Beaupert text, and there's at least two per category here. There's the most common are misdiagnoses, failure to refer, mishandling of medication, failure to provide preventive care, failure to perform routine screenings, and telephone triage. The example I want to discuss involves telephone triage. I'm simply choosing this one to discuss because at my current job as a nurse, I take a lot of triage calls and relay a lot of information between providers and patients, so it really kind of sparked my interest. So the example is, a 9-year-old boy who was thought to be previously healthy developed nausea and vomiting, poor appetite, lethargy, and weakness over 3 days. The boy's father called the pediatrician's office on a Saturday night. A nurse practitioner was on call. When the nurse practitioner returned the call, the father said the boy had slept for an entire 24 hours straight, but had been carried downstairs to watch TV and was sipping ginger ale. He had had some rectal bleeding and some bleeding from his mouth the past day. The nurse practitioner told the boy's father it sounded like a viral illness, but that the rectal bleeding could be something different. So she asked a few questions. Was he alert? The father said yes, but he's very tired. Had he passed any urine? The father said yes. Did he have a fever or rash? The father said no. Then the nurse practitioner asked the father whether he thought the child needed to be seen right away. The father said he thought it could wait until morning. The nurse practitioner plans to see the father and son at 8 a.m. She instructed him to call back if anything developed during the night. The nurse practitioner told the father to push the ginger ale and make sure the boy was urinating. There was an audio recording of the call. The nurse practitioner documented her advice in the medical record, including that the father was offered an ER visit, although the audio recording did not verify a specific offer of this visit. When the father checked on the boy at 4 a.m., he was sleeping, but the father noted that his breathing rate had increased. He did not call. In the morning, the father again checked, and the boy was not breathing. The father called 911 and started CPR. When the ambulance arrived, the child was apneic and pulseless, with fixed and dilated pupils, and his corneas were cloudy. At 9:30, the child was pronounced dead. An autopsy found the cause of death to be diabetic ketoacidosis. There was no previous diagnosis of diabetes. Patient's blood sugar was 1,165, potassium was 7.1, and the A1C was 15.3. The parents sued the nurse practitioner, alleging wrongful death of their son due to negligent delay in diagnosis and treatment of diabetic ketoacidosis. The case was settled for an unknown amount. So what can we learn from this example? First, don't ever put the decision about whether the situation could wait until morning on a parent. If giving telephone advice, there should be protocols in place as to the questions the provider should ask and when a patient should be referred, and there should also be a mechanism to record what was discussed and what advice was provided. In a nutshell, telephone triage adds a significant layer of risk to the already risky business of diagnosis. When in doubt, or if there are any urgent issues like difficulty breathing, bleeding of any kind, or a patient who cannot stand when he previously could, always recommend an immediate ER visit or ambulance call. In this scenario, had the nurse practitioner advised the father to call 911 or take the patient to the ER, the father probably would have complied. Let's turn our focus back to the National Practitioner Data Bank. If any of you are like me, I had heard of the NPDB but didn't really know what it was. By definition, it is a repository for damage award data, which means payments from professional liability insurance companies on behalf of their clients to injured parties for successful malpractice claims. NPBD also records adverse actions against providers by licensing boards, hospitals, and professional quality assurance committees. The NPDB is the responsibility of the U.S. Department of Health and Human Services. It was established under law, and the intention was to encourage hospitals, state licensing boards, and other healthcare entities to discipline those who engage in unprofessional behavior and to restrict the ability of incompetent healthcare practitioners to move from state to state without disclosure of their previous dangerous performance. Under the law, any malpractice insurer who pays any amount to a plaintiff on behalf of a nurse practitioner in a malpractice case must report that payment to the NPDB. There are a few instances in which cases need not be reported, and that is when payments to patients come directly from a nurse practitioner or any healthcare entity. The malpractice insurer must also report damage awards to state licensing boards. And all licensing boards are required to report adverse licensure actions, hospitals are required to report adverse clinical privilege actions, and professional societies are required to report adverse professional society membership actions. Further, hospitals are required to check the NPDB data every 2 years before granting clinical privileges. Although the general public does not have access to NPDB data, individual nurse practitioners do, and they may have access to their file and add a brief comment to give their version of an incident listed in the database. A nurse practitioner may be following practice guidelines as a matter of law policy and/or good practice. Certain states require a nurse practitioner to establish practice protocols or guidelines, with or without a physician's input. These written guidelines, if mandated to follow, must abide by certain criteria. A few of the guidelines most important to note are: do not write guidelines so detailed that they cannot reasonably be followed in everyday practice. Always follow the guidelines. If the guidelines are inappropriate for a particular patient, document why an alternative tact is being followed and why. The Federal Agency for Healthcare Research and Quality publishes evidence-based clinical practice guidelines in the National Guideline Clearinghouse. So a nurse practitioner who's caring for patients with a condition addressed by these guidelines that appear in the clearinghouse should follow those guidelines or document why the guidelines are inappropriate for a particular patient. Like we've mentioned, although mistakes and malpractice lawsuits are inevitable, the good news is that there are ways to prevent them. First is be careful about establishing the patient-provider relationships. Remember earlier when we talked about what constitutes duty, and that is a patient-provider relationship. Whether that relationship is developed in the office or casually with a friend in a social situation, that person is now considered a patient, and therefore the nurse practitioner should exercise all of the cautions and standards that he or she would exercise with a patient in an office or hospital setting. Second is know the standard of care and practice within it. This one's pretty self-explanatory. Third, if practice guidelines or protocols have been adopted by the office or agency, follow them. Again, self-explanatory. Fourth, when in doubt, take a conservative approach. Fifth, which is something we already talked about earlier, rule out the worst diagnoses earlier on. And lastly, know the limits of training and expertise, and always, always, always follow up. If preventing the lawsuit is inevitable and it's going to happen, it's nice to have a little insight or a game plan on just what you are supposed to do, because the law is a very confusing entity. First, call the nurse practitioner's professional liability insurance company to report the lawsuit. Don't talk about the lawsuit with anyone but the nurse practitioner's attorney, and especially do not talk about the case with the patient or the patient's attorney. Although this is something that should be done for any reason, never change a record after learning of a lawsuit, as this will more than likely be caught and will cause further legal issues. It is also important to prepare for your deposition well. A deposition is a pre-trial information gathering session that can be just as important as a trial in terms of the need for preparation. What a nurse practitioner says in deposition can lock the nurse practitioner into what he or she may say at trial. And always think carefully before agreeing to settle, because settlement awards will appear on nurse practitioners' NPDB record. Researchers who compared the time physicians spent with patients with malpractice history found that providers with 2 or more malpractice claims against them spent on average 15 minutes with each patient, whereas providers with no malpractice claims against them spent an average of 18.3 minutes with each patient. All nurse practitioners know that good provider-patient communication means better outcomes and higher patient satisfaction, and we all know that satisfied patients are less likely to sue. Moral of the story is spend more time with your patients. Patients hate to feel rushed, and this is something that is often not understood by hospital administration. For example, in the cardiology clinic where I work, we see patients every 15 minutes, except all new patients get scheduled for a 30-minute visit. So how does anyone think that 15 minutes is enough time for a cardiology appointment? Many of our providers get very frustrated with this time constraint because they end up spending the quality time with their patients as necessary, but then end up getting very behind schedule, causing undue stress on everyone, including the waiting patients. Although I will not go into detail about this issue, it is important for a nurse practitioner to remember that their actions will almost always affect the physician he or she is practicing or in contract with, and oftentimes, if malpractice is being taken up, the physician will be held more liable than the nurse practitioner. As we have already discussed, we are all human and mistakes are bound to happen, and when they do, malpractice insurance provides a comfort factor that is well worth the money. There are numerous malpractice insurance companies, all with enticing deals and savings in an attempt to gain your business. The first question many nurse practitioners ask is whether or not I need insurance if my employer covers me under their policy. The answer is yes, always yes. Why? Because people will always cover their own butt over someone else, especially in the medical field. As our book states, a lawsuit fractures collegial alliances. The human tendency is to deny one's own liability and blame others. It is in the best interest of the nurse practitioner to have malpractice insurance. Another commonly asked question as well is, am I more likely to be sued if I have malpractice insurance? There's no sure way of telling this, but patients don't usually know whether a nurse practitioner has malpractice insurance or not. There are also different kinds of malpractice insurance, and it's best to get occurrence insurance, which covers any incident that occurred while the nurse practitioner was insured. When deciding which company's policy is best, it is always best to follow a few simple rules. Choose a company that is located in the United States, and this is just in case the nurse practitioner has to sue the company. Choose a company that has been in business at least 10 years and has a stable financial rating. It's really hard to list the pros and cons of medical malpractice, so I've done the best I could and tried to come up with a few ideas for each. Obviously, the biggest pro is the protection of the patients and the public from bad providers or doctors who don't have the patient's best interest at heart. Another pro is that regardless of how much providers don't like it, it does hold them accountable for their actions. We have chosen a profession that places the lives of other human beings in our hands, so I think we should be held accountable for the decisions we make. Malpractice also holds practitioners to common standards that we all must meet and be judged upon. There are also some cons of malpractice, obviously. There is the obvious emotional and financial burden of malpractice. Even if the suit falls through, the emotional burden that the practitioner endures during the entire process can be career and life altering. There are also vindictive patients who are what we like to call sue happy. They're very hard to please and have the no one does anything right mentality. Lastly, malpractice causes nurse practitioners, as well as other practitioners, to not be able to practice to their full potential, raising the cost of medicine because practitioners start to overprescribe and order extra testing just to cover all bases to make sure they aren't missing anything. Malpractice has an obvious impact on the role of the nurse practitioner as a provider. Any healthcare provider is subject to malpractice. As we have already mentioned, nurse practitioners make so many decisions throughout their busy days that there are bound to be mistakes here and there. As physician deficit is on the rise, nurse practitioners are starting to assume greater responsibility as they move into the primary care provider role, which makes them much more vulnerable to malpractice exposure. With increasing autonomy, nurse practitioners are no longer being shoved under the wing of physicians, but practicing under their own knowledge and license, which again makes them more vulnerable to practice exposure. The most frequent allegations of malpractice made against nurse practitioners are failure to diagnose and delay in making a correct diagnosis, failure to provide proper treatment and care, and medication prescribing errors. And as we've already mentioned, depending on the state the NP is practicing in, the nurse practitioner may pass a substantial portion of their liability to their supervising physician. Lastly, I wanted to find a few statistics to point out just how rare malpractice suits are, and without undermining the seriousness and importance of understanding the matter and the fact that although the occurrences are rare, they do happen. And when they do, it's important that nurse practitioners understand what to do and when to do it. Malpractice litigation against nurse practitioners is on the rise, with more cases being filed and higher judgments being awarded. As of 2017, there are more than 222,000 nurse practitioners licensed in the United States. Despite this high number, our malpractice rates remain among the lowest of all healthcare providers at 1.9%, despite a small increase of 0.6% from 2007 to 2016. Recent data has also shown that the average malpractice award against a nurse practitioner has risen from 186,000 in 2007 to 221,000 in 2011, almost a 20% increase. Lastly, nurse practitioners have been proven to be less likely than both physicians and PAs to be named in a malpractice suit. Here are my references, and thank you all for listening.